Hi, everyone. Welcome to the show. Former police officer Kim Potter announced in court today that she will testify. But the judge then pauses and asks if maybe she needs more time to decide. We'll take you inside the courtroom. But first, breaking news tonight in the Alex Baldwin shooting investigation. Police in New Mexico have issued a search warrant for Baldwin's phone. It's, of course, in connection to the fatal October 21st shooting of cinematographer Halyna Hutchins on the set of his film Rust. The search warrant, requested by Santa Fe sheriffs, authorizes police to review all text messages and photos on the actor's iPhone, as well as any stored location data. Investigators previously asked him for his phone, but he and his lawyer apparently refused without a warrant. The warrant saying in part, affiant, meaning the person who's requesting it, is requesting a warrant for the seizure and search of Alec Baldwin's cell phone to search for any evidence relating to the death investigation of Halyna Hutchins. Affiant believes there may be evidence on the phone due to the individuals using cellular phones during and or after the commission of crimes. Such information, if it exists, may be material and relevant to this investigation. Affiant was also made aware there were several emails and text messages sent and received regarding the movie production Rust in the course of interviews. What I am unclear about is why he refused to hand it over voluntarily. The warrant says, quote, Affiant requested Alex's phone from him, as well as his attorney, and was instructed to acquire a warrant. Joining us now, Terry Austin and Brian Buckmeyer. Both are attorneys and hosts for the Law and Crime Network, which I founded. Thank you both for coming on the program. Appreciate it. All right, let me start with you, Brian. Why do you think that Alec Baldwin and his attorney would have required them to go get a warrant rather than giving over his phone voluntarily?
So it doesn't look like, when you're talking about what's going on with Alec Baldwin, whether or not they're going to stop this ability to get the search warrant. The search warrant seems to be pretty specific in what they're looking at. And so it's going to be interesting to see what they pull out of it, because a lot of what's in this cell phone could be turned over to these individuals, that being the affluent, that being the people searching to go into the cell phone. And so I think it's going to end up getting turned over.
All right, let's sort out. I think we're having a communication delay there with Brian. We'll sort that out. In the meantime, Terry, what do you make of this? Why do you think that he didn't just hand it over voluntarily?
Well, he should have. To me, it indicates he has something to hide. He has a message saying he knows. The question is, what does he know, and when did he know it? Did he know that they had shortages as far as the film was concerned, that they weren't getting paid enough, that they had to travel too far? All of that will lead into whether or not there was some sort of criminal negligence, whether there was something going on that set that he should have been paying attention to.
But I just don't get how he wouldn't have understood that, of course, they're going to get access to it. Let me play a piece of sound. This is what Baldwin told George Stephanopoulos about the investigation and about whether he was a suspect, et cetera. Let's listen.
You're not worried about being charged?
I've been told by people who are in the know in terms of even inside the state that it's highly unlikely I would be charged with anything criminally. I've spoken to the sheriff's department multiple times. I don't have anything to hide.
All right. Well, first of all, there's a really dumb statement to make about telling what the sheriff's department is or isn't going to do. But he says he's got nothing to hide. Do we have Brian? Okay. So, Brian, the thing I'm trying to figure out here, and that I was just talking to Terry about, is why he wouldn't have just handed over the phone voluntarily and why he would have forced them to go get a warrant.
Yeah, sorry about that, Dan. So yes, when it comes to handing over information, many people will just think, if you're not guilty, hand it over. But your lawyer is going to probably tell you not to. The same way your lawyer will tell you not to speak when you're given your Miranda warnings. Wait until see what the prosecution provides, because the major thing when it comes to search warrants is whether or not it is too broad or unconstitutionally vague. And so what I would say as someone representing an individual, say, let's see what the search warrant is. Let's see what they're looking for. Let's see if it goes beyond the scope of what they should be looking for, and then we will move accordingly. That's how I would advise my client. I think that's what Alec Baldwin's lawyers are advising him as well.
But, Brian, I think in high-profile cases where you've got a guy who's out there doing interviews about the case, right, and saying, I did nothing wrong, they're not going to charge me, I'm not hiding anything, that once you're right in terms of a typical case, right, typical lawyer advice, force the prosecution to do that. But typically you don't have the person, one of the people who are being investigated, out there publicly pronouncing that he's not going to be charged, that he isn't hiding anything. And I think that with that in mind, it doesn't make any sense to me that they would force him to go get a warrant.
Yeah, so here I think would be an example of an attorney not really remembering that although we may not like it, I kind of put myself in that category as a practicing attorney, sometimes your client is tried in court and tried in the court of public opinion. And so what you're saying is correct, Dan, in terms of the court of public opinion. What's this going to look like? Are we sure we want to keep this cell phone away from the authorities? Because really, as far as we know from what Alex Baldwin has been telling us, there shouldn't be that much, if any, incriminating information in terms of his communications as it applies to the Rust investigation and just talking back and forth with individuals at the scene.
Yeah, and I think what happens in these cases, Terry, is a celebrity like Alec Baldwin doesn't want people seeing his phone, period. We saw this happen in the Jussie Smollett case. I mean, in addition to the fact that, you know, I'm sure that what Jussie Smollett didn't want them to see was other stuff in there. But again and again, we see celebrities not wanting people to see their phones because there's other stuff and there's pictures and there's this and there's that. And, you know, you can't have it both ways.
Here's the thing. At the end of the day, they're going to get the phone. And if you keep the phone, what are you doing between the time when they make the request and you give it over? Are you trying to delete images and text? No, I hope not. And you may as well give it to the authorities. Theoretically, they are not going to give it to the public, and they're not going to be looking at private information. So I think he should have given it over.
Well, and I think that this represents a new point in the investigation. I mean, you would think that up to this point, Brian Buckmeyer, that they would be pretty advanced in where they are in the investigation, right? And if Alec Baldwin isn't a big issue, you know, we're now, you know, a couple months in to this already, and that they either would have gotten the phone at the outset, or what I think probably happened now is based on interviews that they did with other people, they suddenly said, wait a sec, we need to know more about what Alec Baldwin knew and when he knew it.
Absolutely. And it's actually the latter, Dan, because when you look at the 8-page subpoena for the cell phone, it actually goes through the investigation of who they spoke with and when, and they started to realize, hey, there are some communications between these individuals over their personal cell phones, talking about the set, talking about when they're going to meet, talking about what needs to occur in the background of making sure this movie works. And so I don't think they came across this idea of, hey, let's just go and get a cell phone right off the top of their head. They did some interviews, and part of the interview is actually in the subpoena justifying why they need this information. And so that's why we're seeing this come up later rather than sooner.
And I have to say, Terry, up to this point, I've kind of minimized the criminal investigation of Alec Baldwin, meaning I've always said, you know, well, he could be investigated as a producer, et cetera. And I've always kind of thought that he was right, that Baldwin was right, that yeah, they're not really going to charge Alec Baldwin. But once I see them moving this way, and you read the 8-page, as Brian just said, the search warrant affidavit, I don't know. Now I start to wonder whether maybe they are looking at Alec Baldwin and possible charges.
I started wondering when he did the interview with George Stephanopoulos, because why are you doing an interview? You're trying to, from a PR
because
perspective.
He's Alec Baldwin, Terry. He can't stop himself.
Well, that's the problem. That's the problem. But he's looking to defend himself early on. He's getting his PR together. He's making sure he's saying, look, I didn't pull the trigger. That's the first thing he said. And, you know, he also said right at the top of that interview the fact that this isn't about me. It's about the people who were killed and injured. So he really is trying to make sure he's defending himself both civilly and criminally. And so I think there's some fault there.
Finally, Brian Buckmeyer, if you're his attorney now and you've now seen this search warrant, are you saying to him, you know, I don't know, maybe be a little bit nervous?
Not quite, because yes, could he be a target of a criminal case? Absolutely, but he could also be the linchpin. And so at this point in time, I would start to tell him, you know what, we need to see how we need to play this. Are we going to be the supporter of this investigation, again, looking at the court of public opinion as well as a legal standpoint? Or are we going to be the person that kind of lawyers up and says, hey, maybe you're coming for me? I would try to lean my client towards being the person who is supporting this investigation. But of course, that depends on the conversations we're having behind closed doors.
All right, Terry and Brian, stick around because there's some other legal news that both of you have been covering extensively. And that is former police officer Kim Potter announced today that she will testify in her own defense. This as her former boss, the police chief, defends her actions on that day that she shot and killed Daunte Wright. That's up next. You know, I have said since day one of the trial of Minnesota police officer Kim Potter that I think the case will all come down to her testimony. And today, she announced in court that she will testify. Potter shot and killed 20-year-old Daunte Wright in April after seemingly mistaking her handgun for her taser. Wright was pulled over for an expired tag, but then when officers realized he had an outstanding warrant for a weapons violation, they tried to arrest him. He resisted, got back in his car. Here's the moment of the shooting that is obviously critical in the trial. Prosecution rested its case this morning. The state presented more than 24 witnesses over 6 days. Today, we did not hear the defendant testify, but there was an interesting interchange with the judge about her decision to do it.
Ms. Potter, do you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay.
Well, I was hoping we were going to have the second part of that, where the judge pauses and says, are you sure that you want to do that? Which was an odd interchange. If we can try and cue up the entire piece of sound, we'll play it in a minute. The defense's first witness was a use of force expert and a former assistant police chief who said that Officer Potter and her fellow officers on the scene had the responsibility to take Daunte Wright into custody.
Was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested, and there's consequences if you don't.
We also heard from Officer Potter's former police chief, who said that from what he saw on the body cam footage, she followed policy.
After viewing all of those incidents in the body-worn cameras, did you see anything based on your knowledge and experience that her conduct was consistent with her training at the Brooklyn Center Police Department?
When I viewed both camera angles and had all the data in front of me, I saw no violation.
No violation of what?
Of policy, procedure, or law.
And the policy and procedure at Brooklyn Center Police Department, to your knowledge, since you're the chief, followed the law of use of force, is that right?
Yes, it does.
He also said that part of the reason he was forced out of the department was because he failed to fire Kim Potter.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Back with me, Terry Austin and Brian Buckmeyer from the Law and Crime Network. Brian, any surprises here that she's going to testify?
No. In many criminal defense cases, it's rare for a defendant to testify, but that kind of flips a little when you start talking about use of force or self-defense, and it flips even more when you're talking about officers. They've got to almost take the stand and explain, why did you do this? Walk us through the subjective. We can see the objective, but walk us through that subjective mindset as to why this needed to occur. The difficulty I'm going to see here for Kim Potter is we see her reactions directly after the shooting, and she herself believes she's going to go to jail. It's going to be interesting to see how she gets from underneath that.
Well, I would think that, Terry, that the way she would address that would be not to say that the shooting was justified, right, which is part of the argument from her team, but to say that it was simply a mistake and that she was horrified, which I've always believed is a much stronger defense for her than to say that somehow even the use of a real gun was justified.
You hit it on the head. Why are they saying it would have been fine if she used the gun? It would have been fine if she used the taser. You can't argue that. Just argue it was a mistake and that she was trained well. And I understand why they're doing it, but I do think it was a mistake. And her words will come back to bite her. The fact that she was afraid, that means a little bit she knew she wasn't following policy.
And we talked about this the other day, but Brian, I don't know. It seems to me that those words help her. I mean, I don't know if we have the sound here, but where she's sort of, almost crying after it happens. And she's saying, I'm going to go to jail. I can't believe I shot him, etc. I know that as a technical legal matter, there is something in that where people will say, well, she knew she'd done something wrong. But as a practical matter for the jury, I think that helps her in demonstrating that this was just a horrible mistake that shouldn't lead her to go to prison.
So the difficulty with using the word mistake, Dan, is what's going to be given to the jury. We can talk about, was it a mistake for X or was it a mistake for Y? What's the definition going to be given to the jury? And when we talk about culpable negligence, which is what actually is, to give an example that I often give my clients, when I fall asleep on the couch and I forget to put my food in the fridge and my wife shows up and says, why'd you do this? That's a mistake, right? I slept, I'm sorry. But if I'm informing my client as a public defender about taking a plea, and by law, I'm supposed to tell them about any collateral consequences like immigration issues. I've been trained to do that. I went to law school for that. I've been practicing for almost 8 years now. I've taken hundreds of thousands of pleas, and I know I have to do that. Now, if I forget on a client, is that a mistake? Yeah, but that's a lot different than me falling asleep and forgetting to put the food away. And that's what we're talking about here.
Yeah, that's true, except you would be sued. You wouldn't be charged criminally for that mistake, right?
Correct, but I would lose my license. I would not be able to practice the law anymore. And if there was a criminal statute for that, I could go to jail. I simply use that to distinguish mistake as the common aspect and mistake as the legal aspect.
I got it. But here, everyone agrees that there was a mistake made. The question is, did it rise to the level of criminality? Let me play a piece of sound from today. This is number 3. This is the defense expert here basically saying that the force was justified.
In light of your review and the review of all the testimony that you've seen, was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes.
See, Terry, the same way I think the prosecution has, that the defense has a real challenge in suggesting that shooting with a real weapon was justified. I think that the prosecution has an issue in showing that even using a taser was justified.
You're reading my mind. I wrote down notes when I was watching this. They're both saying either way it was okay, and that's not the way to argue this. I think the prosecution would be much better off if they said, look, we know this was a horrible accident, mistake, call it what you want. But there is criminal negligence. And while Brian's example of laying on the couch is fine, here's a better example. If you're driving down the street and you lean over to pick up your cup of coffee and you hit someone in the road and they had the right of way, that's a horrible, horrible mistake. It's an accident, but you are culpable for that. And that's the same thing here. Yes, it was horrible. You could see the pain. She regrets it. But it was a mistake.
We shall see what happens when she testifies. Brian, you'll get a chance to hit back at Terry because we're going to still have you guys back on another topic in a moment. We want to talk up to you about some incredible testimony in the Ghislaine Maxwell trial. But first, Donald Trump still won't drop the claims of widespread 2020 voter fraud. Now Republican candidates are being forced to answer questions about it, and they're tying themselves in knots. Time now for our Mediaite Moments. We check in on the day's bias, buzz, and bull in the world of cable news and beyond. Conservative talk radio host Hugh Hewitt moderated a recent debate among Minnesota Republican candidates for governor. And he asked one question which would think is pretty straightforward. We've added subtitles due to the quality of the audio.
In your opinion, did President Biden win a constitutional majority in the Electoral College? If yes, how definitive is your conclusion? And if no, would you please explain which states you think are in dispute and why?
Now, Hugh knows what he's doing. He knows there is no compelling evidence of fraud that has put any of the states into dispute, but he wants to test if the candidates are willing to cross Donald Trump. There were 5 candidates. First, former state senator Scott Jensen.
I can't know what I don't know. And I think that we have to take that attitude towards 2020. I don't think there's any question that we've got enough shenanigans that we should want to do something about our election integrity.
Wait, I can't know what I don't know? Donald Trump claims to know. I'm not sure shenanigans is a real allegation either, but next up is Dr. Neil Shah.
I grew up in a suburb of Chicago, but the governor is this dictatorial tyranny, long and aided and abetted by the Secretary of State. We all need to have faith in our elections.
What? Dr. Shah talked about voter ID but never answered the question. Now, Mayor Mike Murphy.
I do believe there was voter fraud and massive scale across this country.
All right, that's as close to a clear answer as we've gotten so far. Next up, Paul Gazelka.
I don't think the election was fair, but I do think we have the results that we have in the Electoral College is the way that we determine the election.
We have the results we have is another way of saying it is what it is, relatively speaking. We'll take that as a kind of yes. Then there was this answer from Michelle Benson.
The more we watch, the less they cheat. So you be the watchers. That is something you can do independent of everything else. And I will champion easy to vote, hard to cheat.
Easy to vote, hard to cheat, sure, but that wasn't even an answer. Hugh Hewitt was so confused by that answer, he asked it again.
Senator Benson, a follow-up, though. Did President Biden win?
He was certified by Congress as having won the Electoral College.
It is stunning to see them tie themselves in knots to, well, it's obvious why. That's our wrap-up of the day's media bias, Buzz, and the Bull. Coming up, more on Donald Trump. He's on the attack against Republicans who compromise. He's gunning for Mitch McConnell now, while his other favorite target, Liz Cheney, is getting destroyed in the polls. Up next. You know, ever since Mitch McConnell condemned former President Trump at the former president's impeachment trial, the relationship between the two has been, shall we say, strained, to put it mildly. But yesterday, Donald Trump took his criticism of the Kentucky senator to a whole new level. In a scolding statement, Trump torched McConnell for what he deems to be insufficient efforts to fight Democrats on really just about anything, including a pair of spending bills, one of which was a bipartisan infrastructure bill, which has been passed, and the other is still on the table. Trump attacked McConnell for his lack of courage in playing the debt ceiling card as well. Quote, he has grabbed defeat from the jaws of victory. How this guy can stay as leader is beyond comprehension. This is coming not only from me, but from virtually everyone in the Republican Party. He's a disaster and should be replaced as leader ASAP. Now, McConnell, obviously, didn't want to engage when confronted about Trump's comments at a press conference this afternoon.
President Trump seems intent on maybe replacing you and trying to get candidates on board with that dynamic. So what do you say to that dynamic as you head in maybe the wind at your back? And to those who would want to replace you? You say what?
Good try. Next subject.
Now, you could write all this off as more of the same from the former president, but I'm not so sure. The part of his statement that caught my attention was, quote, this is coming not only from me, but from virtually everyone in the Republican Party. This was clearly a call to arms from the former president, a signal to the rest of the party, to anyone that wants to stay in Trump's good graces. They're going to have to pick a side. There's no more straddling the fence. There's no compromising with Democrats. You can support me or you can support Mitch McConnell. And increasingly, evidence is mounting that many Republicans trying to win national office without Trump's backing are really in a difficult spot. One person who's trying is Congresswoman Liz Cheney. She's looking to survive a primary challenge from a Trump-endorsed opponent, but the numbers show she is in serious trouble. Cheney's opponent, Harriet Hageman, is dominating the race, with 56% of Wyoming Republicans backing her to dethrone the incumbent. Cheney languishing way behind with just 18%. Look, I have no stake in who wins that election. I don't live in Wyoming. The residents there should decide for themselves who they want. I am interested in what it means for the prospect of any meaningful bipartisan government being done in 2022, and about what happens now in terms of Republicans being forced to choose. Let's bring in Tara Setmeyer, long active in Republican politics and a resident scholar at the University of Virginia Center for Politics. Tara, great to see you. So am I making too much of this particular statement from Trump?
No, I just think that for those of us who've been paying attention, this isn't new, right? Donald Trump has been attacking Mitch McConnell all year long. Headline after headline, since McConnell spoke out against Trump after the insurrection, and McConnell actually gave probably one of the greatest speeches of his career after that. And he was honest because everyone's emotions were pretty raw considering a violent insurrection had just happened. And he's never recovered from that with Trump. Now, Trump was never a big fan of McConnell's because he doesn't look the part. And we all know how superficial Donald Trump can be. He never really understood the seriousness that Mitch McConnell brought to the job as Senate Majority Leader. Now, say what you want about Mitch McConnell, but he is an absolute master at political brinkmanship and understands the Byzantine rules of the Senate. And if it wasn't for Mitch McConnell, Donald Trump would have no legislative accomplishments. He can thank Mitch McConnell for getting anything of his agenda passed in the Senate and for 3 Supreme Court justices, which is basically Donald Trump's whole legacy legislatively. So, you know, it's interesting that now Donald Trump, who has no interest in governing, we already know this, and it's clear the Republican Party isn't serious about actual accomplishments in the legislative arena, because if they were serious about that, there would be no choice. It would be Mitch McConnell, not Trump.
But are they going to be forced? I mean, is Trump truly going to force mainstream Republicans to choose between McConnell or me?
Absolutely. He's already been laying the predicate for that. We know the reports of the pilgrimage down to Mar-a-Lago happening as we speak, with all of these Senate candidates and major candidates running for Republican office are going down to Mar-a-Lago to kiss the ring. Donald Trump is the head of the Republican Party. As much as Mitch McConnell wants to be, he doesn't have control of the party anymore. It's Donald Trump. And Donald Trump has a much larger war chest than Mitch McConnell. And something else that's happening now that's a little bit different than before. I mean, Mitch McConnell was probably the most powerful man in Washington behind the scenes. But now you actually are starting to see a break, even with donors, because Mitch McConnell entered into the bipartisan infrastructure agreement that gave the Biden administration a win. Now, it wasn't just a win for Biden, it was a win for the American people and a win for Kentucky, frankly. But the Republican donors are all about owning the libs. They don't want to give anything to Democrats. And so they're very upset with Mitch McConnell allowing that bipartisan deal to go through. So Trump isn't completely wrong when he says that there are other people who are upset. You've got Tucker Carlson over there, who is the megaphone of Donald Trump on Fox News, with a really large audience, and he has a lot of influence. He's been disparaging Mitch McConnell. So I wouldn't be surprised if you start to see people gravitating who normally would, side with Mitch and just kind of ignore Trump on this, but they can't, because we see what happens if you step out of line. Donald Trump is the Republican Party, period. There are no mainstream Republicans anymore. Maybe you can fit them in a canoe at this point.
All right, Tara Setmeyer, I'm sure you can see that that's frustrating for you. That's your party, and I see
not anymore.
the picture of Lincoln there in the background with it's sort of an interesting combination of Christmas stuff with some pop constitutional and historical art.
That's
Tara,
right.
thank you very much.
Sums me up.
Good to see you.
Merry Christmas, Dan.
You too. Coming up, Ghislaine Maxwell's defense set to begin in an attempt to dispute and discredit the alleged victims, including calling a false memory expert and a former Jeffrey Epstein employee. That's next. The defense began its case in the federal sex trafficking trial of Ghislaine Maxwell, Jeffrey Epstein's longtime confidant and alleged co-conspirator. 4 alleged victims testified with often heart-wrenching accounts of what they claim Epstein and Maxwell did to them. But the cross-examinations were tough, often highlighting inconsistencies in their accounts. Today, one of the defense's star witnesses took the stand, Elizabeth Loftus, a psychologist and so-called false memory expert. She's testified in hundreds of trials, including a number of high-profile, controversial ones like O.J. Simpson, Michael Jackson, Bill Cosby, Harvey Weinstein. The defense hopes that her testimony might help convince the jurors that the memories of Epstein's accusers are unreliable. Maxwell's lawyers contend that her accusers have misremembered their experiences or invented them with her and Epstein, and in some cases changed their stories to better fit a narrative being pushed by others. Loftus walked the jury through the stages of memory. She also testified that people can remember things differently from how they actually happened because she said memory isn't like a recording device. Quote, "We don't just record events and play them back like an idea." She told the jury, "We often take bits and pieces of our memories and construct what feels like a recollection." Things started off on the wrong foot for Maxwell's attorneys after federal judge Allison Nathan denied the defense's request to have 3 witnesses testify anonymously on her behalf. But then the defense's first witness, her former personal assistant, Kimberly Espinoza, downplayed Maxwell's role in Epstein's life. Espinoza, who worked for Maxwell from 1996 to 2002, called her former boss Epstein's estate manager and testified that Maxwell never lived with Epstein during the time she worked for Maxwell. Espinoza, who also previously worked as an assistant for Epstein's lawyers, also described the deceased convicted sex offender as a giver and someone who gave generously to charity, which probably didn't help with her credibility. When it came to Epstein's accusers, Espinoza said she saw nothing during her 6 years working for Maxwell that pointed to either Maxwell or Epstein behaving inappropriately with underage girls. But on cross-examination, she admitted she didn't work out of Epstein's homes, where the accusers have alleged the abuse took place. Now, many thought Maxwell would take the stand in her own defense. I kind of thought she would. And while it's still unclear if she will, her lawyers were given until tomorrow to decide, but it's looking less likely since Judge Nathan said to expect closing arguments to begin on Monday. Back with us again, the co-host of the nationally syndicated program Law and Crime Daily, attorneys Terry Austin and Brian Buckmeyer. Terry, any chance you think Ghislaine Maxwell will still testify?
Not because of the timing. I think she's going to want to testify. I think she probably should testify to talk about what was happening. Because remember, this is basically she said, she said. And so I think if she testified, it would definitely help. Cross-examination would be horrible, though.
Yeah.
But because of the timing, I think she probably won't. There's no way you could get finished with both the direct and the cross-examination. So it doesn't look like she's going to.
Brian, you agree?
Yep. Yeah, I would agree. I actually kind of slightly disagree with you, Dan, initially that I didn't think she was ever going to testify. She would have been bombarded with every why under the sun, and I think that would have been detrimental to her. And so I kind of expected her not to testify and really rely on her defense team and poking holes here, there, and everywhere to kind of help carry this case for her.
Well, I will tell you that based on the cross-examination, I haven't been in court, but I have been reading transcriptions coming out of court. It does seem the cross-examinations have been very effective of these 4 women who are testifying, and I think that may be playing a role here in the decision not to have her testify. Brian, do you agree with that assessment?
Oh, absolutely. Every defense attorney worth their salt will tell you that from the time you know you're going to go to trial, you prep your clients for the possibility of testifying. In some cases, you have to, as we talked about earlier in the show with Kim Potter. In some cases, you don't. In some cases, you're on the fence. And I think what we're seeing here is when you're kind of sort of maybe on the fence and the cross-examinations feel like they're going your way, while you have prepped your client, this is a time that I would turn to my client and say, you know what? Maybe you don't need to testify. Maybe there's too much damage that can be done.
Do you agree with my characterization of the cross-examinations? I mean, I think that people who aren't watching the trial that closely aren't getting the fact that there have been real problems with the prosecution, right?
Right. I mean, the prosecution tore up Jane, sorry to say, the fact that at one point she said, well, I, basically have not seen Maxwell and Epstein together, and I don't remember the first time. And then, on the stand, she's now saying that she remembers the first time, she knew where she was, she knew what was going on. And I think that that is saying that her credibility is not that strong.
Particularly when we're talking about reasonable doubt. Brian, what to make of this decision by the judge not to let these 3 witnesses testify anonymously?
I think it was absolutely correct. I think the judge themselves said that this is unprecedented. And let me step back and say why. Typically, you keep someone anonymous when they are a victim of some sort of crime. There's some sort of mental or physical fear of recourse that could happen to them. But when the judge pressed the defense as to why these witnesses should fall into the category of victims who testify anonymously, there wasn't really any leg to kind of stand on as to why they need to be anonymous. So I think this was a correct decision.
We know why, right? We know why. They don't want to be associated with Ghislaine Maxwell. They right? I mean, they don't want to be in the paper. They don't want people knowing that they were part of the defense of Ghislaine Maxwell. I get it. Anyway. All right. Terry Austin and Brian Buckmeyer, it is great to have you both here. Really appreciate it. Hope to see you again soon.
Thanks, Dan.
Thanks, Dan.
Coming up, a man refuses to roll down his window for police officers. He then pulls a gun and starts shooting at them, shattering that window. We are on scene with police for this insane encounter with the body cam footage. Coming up next. Welcome back. We are on scene tonight with body cam and dash cam video from the Placentia, California Police Department. An officer was patrolling an area that had seen an uptick in crime when he spotted a suspicious vehicle parked behind a business. He approached the car and tried to talk to the driver.
Open the door. Don't reach for anything. Open the door now. Why? I'm the police, dude. Open the door now. Roll down the window. I'm giving you a lawful order, dude. You're being detained. Roll down the window.
The officer told the suspect to open the door or roll down the window for 5 minutes. He calls for backup, and officers started putting a plan together to get the suspect, Matthew Wong, out of the car. Now, as more officers arrived, the suspect put the car in reverse, nearly smashing into a police vehicle that had pulled behind to box him in. Police then saw Wong reaching for something in the car. Now, officers fired a 40-millimeter foam bullet at the window to try and shatter it.
Put your hands up above your head and start reaching around the vehicle.
Hey, if he starts reaching again, we're going to He's reaching
right
now.
40 the window.
Hey, 40 the window.
40 Mike, 40 Mike, 40 Mike.
By that time, dispatchers ran a record check on Wong, found he had several guns registered to him. That led officers to fear he may have been reaching for a weapon in the car. But police couldn't see because of the heavy tinting on the windows. Police fired 2 more foam bullets at the window as they continued to give instructions.
Matthew, stop reaching around the vehicle. Put your hands above your head. You are being detained. Open the driver's door.
40 Mike, 40 Mike. Shots fired.
Everybody good. We're good.
Now, Wong had shot at police who returned fire. Officers approached the car and found an untraceable ghost gun with no serial number in Wong's lap. He died at the hospital. A police car was shot when Wong opened fire. Fortunately, no officers were injured. Joining me now is Volusia County, Florida Sheriff Mike Chitwood. Sheriff, thanks for coming back on the show. Appreciate it. All right, take us through this from the officer perspective. It seems clear now why the suspect wouldn't roll down his window, but let's start from the point of what the officers know and don't know and the use of the foam bullets.
Dan, the first thing is this is a well-led, well-trained, well-equipped, and backed by their county council or city council police department. Officer on patrol, suspicious vehicle, high crime area, time of night, great job. Activates his body camera, does what he needs to do. Can't see into the car, heavy tint, obviously condensation from being inside. They are giving commands not only verbally, but they're using a megaphone. He calls for backup. They block him in. They know something's not right. There's a part of this video your viewers don't see where he's giving commands to roll up the window, roll down the window, and he can't follow them. When they ask him to roll it down, he rolls it up. When they ask him to roll it down, up, he rolls it down. He does a fantastic job doing that. And then using less lethal munitions that won't cause a fire, like a tear bomb or a flashbang inside the car. They use less lethal to get video inside that car. Then they fire the munitions in. And what's important for your viewers to see, Dan, is when the munitions go in, the window breaks in. When he fires out, and you got it right there right now, the glass is falling outward. That's him firing at the officers. They are left with no other choice. They did everything they could to de-escalate this incident. And again, confronted by the unknown, these officers did what they needed to do with professionalism.
You make a very interesting and I think important point about the glass. So let's show again the moment that they try and break out the suspect's window with the foam bullets and the man shoots at police, and think about what the sheriff just told us.
Authentic driver, Sword.
40 Mike, 40 Mike.
Shots fired.
Everybody good. We're good.
That was really important context, Sheriff, because now we watch it again and it makes more sense in terms of the order of what happened and how it happened when you can see that weapon, the glass breaking out and knowing that that's the point when he's firing out at them. Look, do you think that this is a guy, and I've only got 20 seconds left, you think this is a guy who wanted cops to fire at him?
Absolutely. He refused every lawful command. And Dan, think of something else. When they scream out 40 millimeter, they're letting all the other officers know when they hear that projectile fired, it's not law enforcement. It's not the bad guy firing. It's a law enforcement. So use firearms proficiency there.
Sheriff Chitwood, always good to see you. Thanks for coming on. Appreciate it. Before we
Merry
go,
Christmas, Dan, to you, your family, and your viewers.
Thank you. Next week on Dan Abrams Live, join us, you guys, as a guest on NewsNation. Go to our website. Check it out. Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.